coming back to testify. Appreciate it.
Senator Heinrich.
Mr. Kenna, how critical is it for the public to guide the direction of a land use plan for that plan to be effective and successful?
I think it's very important, and I would highlight the fact that planning processes, particularly if they're of any size or duration, create a record, and it's a public record, and that public record underpins all of the decision-making that happens in the plan. So it essentially is the balancing dialogue around the FLPMA questions. And so you can't sidestep that. And you need to make sure that the local knowledge is integrated and not just the social preferences, those are very important, but also where is the mule deer winter range? Where are the cultural resources and cultural properties? Where are the things that we care about? Where are the trails that get a lot of recreation? Where all of those things are very local.
Right.
And they're very specific.
And how does the Congressional Review Act incorporate the public input and the creation of that record?
Well, my concern is that it's the exact opposite. If you think about the perspective of the person who participated in a plan, they've just invested years to get to that kind of endpoint where everybody kind of got together and whatever the deal was the deal. Yeah. And now the Congressional Review Act has sort of taken a political process and put it over the top of that and vacated that.
And with no public, there's no mechanism for public input in the Congressional Review Act. And I want to get at some of the unintended consequences that might create. Mr. Sheehan, with Congress recently overturning a number of RMPs through the Congressional Review Act, one of the limitations under the CRA is that it means that the BLM under the statute can never issue a, quote, substantially similar plan for those areas. Is that correct?
Yes, I believe that's accurate, Senator.
So I'm wondering if an RMP plan allowed for development of oil and gas, development of mining and grazing, hunting in the planning area, and the plan is overturned by the CRA, could BLM ever issue a new plan that allowed those same uses in the same areas?
Senator Heinrich, I believe that, and I'm not a lawyer here, and there's lots of lawyers in the room. There's one right to your left, of course.
I'm not either, but let's take the verbiage.
But if we work under that premise that a CRA pulls this plan back and that a new plan could not be substantially similar, then it would certainly lean into a set of facts around you can't go back and do the same thing again until Congress says you can go do it again. Now, but what it does do is you pull it back is it reverts back to the prior plan that's sitting there.
Which
and,
could
if that allowed for some of those uses, of course,
it could be 40 years old, and that plan may not actually address the uses that are most pressing today, correct?
Yeah, absolutely. When we talk about planning, and I wrote down a comment that Chairman Lee mentioned in his opening comment. It says adapt to changing circumstances, and I thought for a moment, what happens over these 40 years, 45 years, and some of these plans that have sat there, and with the new technologies that have come about, I look at what do we know different about wildlife management and movements and how we can restore habitats. We've got wild horses and burros, and in some of these areas that we have plans for, we don't necessarily want to manage for wild horses and burros in those areas anymore. We
also know where corridors are.
Exactly. We have that technology. Absolutely. It's taught us that.
Nobody
renewable
knew
energy.
Where the mule deer corridors were, where the pronghorn corridors were. And so that doesn't get managed for if we're dealing with a 40-year-old plan.
Exactly. So I guess my hope as a former land manager is if the CRAs are going to be a thing that gets used, let's try to avoid that to any extent possible.
Why not just redo the plan?
A plan can
and
be...
avoid all those unintended consequences.
Yeah, absolutely. And I think if the plans can be done initially, and make sure we do that coordination, cooperation, do all of the efforts we need to, so that we get a better, higher level of buy-in. I would hope Congress does not need to step in on these because, to your earlier point, I don't know what kind of certainty there is for future planning in these areas, and I hope that that's not confounded.
I think one of the things that I'm concerned about is the opening for litigation, because this statute is so vague about what a substantially similar plan would look like, is that you could literally see every permit, whether that permit is for outdoor recreation that Mr. Kramer represents, whether that permit is for oil and gas, whether that permit is for grazing, called into question because of some of these CRA activities. And I think that's something that, that everybody ought to be considering before using such a blunt tool.